And we're live. Welcome to Military Law Talks, where a former military attorney gives my perspective on military law and federal law. And so far, it's been a whirlwind with the new Trump administration, all kinds of court cases, all kinds of executive orders. So here we're going to break it down. If you don't understand what's going on, you're at the right place. I'm going to break it down and put it in language that's easy to understand. So there's been a meltdown today. I don't know if you've heard, but I don't know if you've been on X, but there's been a big meltdown over the federal funding freeze and really the court's ability to unfreeze it. And so I'm going to break that down for you today. We're going to talk about um, the case that several states, New York being the lead, brought against the Trump administration when the Trump administration intended on freezing federal funds for certain programs. And so we're going to break that down today. And I'll help to explain it. So let's kind of give some background. Well, what happened? So initially, the Trump administration Office of Management and Budget, OMB, they issued a 2-page memo, and that discussed different it directed agencies to freeze funding in line with certain executive orders that came out, specifically executive orders canceling the Green New Deal, the Inflation Reduction Act, things like that. And so essentially, OMB said, hey, executive order or executive agencies, in line with new administration, new strategy on funding, pause these programs. And immediately 2 lawsuits were filed. So the one we're going to focus on today was the state of New York and a bunch of other blue states filed a lawsuit arguing essentially that the executive branch didn't have the authority to spend this money that Congress had delegated to spend. And so, or that Congress had said, hey, we're appropriating this money. Now you need to spend it, executive branch. And so the very next day, the OMB 2-page memo was rescinded. So the government lawyers argued, hey, these cases should be dismissed. This is moot, meaning it's over. The courts really have nothing to decide. But the courts went ahead and still heard the case. And so specifically, the case we're going to focus on today is in the District Court of Rhode Island. And so, like I said, this happened a lawsuit that was filed, the state of New York and several other states. And so it's in the district court, but the First Circuit made a ruling today, so that we're going to talk about that ruling and we're going to explain the background. And so really to frame this whole discussion over these cases, it's really, really important to understand a little constitutional law and a little history. So first, to understand how our Constitution set up our government, it set up 3 branches of government. So obviously we have the legislative branch, that includes the Congress, the House of Representatives, and the Senate, and their job is to make the laws. Then we have the executive branch, which all executive power is vested into the president. And then the president is supposed to faithfully execute the laws that Congress passes. And then we have the judicial branch that it settles disputes and also decides. It's the actual language from the Constitution says cases and controversies. Now, the Supreme Court under John Marshall, the head of the Supreme Court, so the Chief Justice, the first Chief Justice, interpreted very early in the days of the Supreme Court that the Supreme Court had the ability to declare laws unconstitutional, that essentially to be a co-equal branch, that was part of their job. And so a lot of the case that we're going to discuss today really discusses the tension between those three branches of government. So there's a lot of tension between the branches, and particularly when it comes to money. So, Congress, under the Constitution, Congress controls the power of the purse, they control the money. So, the executive branch cannot spend money unless Congress gives them the authority to do so. So, Congress tells the executive branch whether or not they can spend money and what they can spend money on. So there's been a lot of history of tension between the executive branch and Congress over money, and it dates back all the way to the Jefferson administration. But it really came to a head during the Nixon administration, and this is a key thing that plays into the cases that we're going to talk about today. So during the Nixon administration, Congress passed a law. Now, the law is not super important to our discussion, but Congress passed a law. Nixon vetoed the law. And then it went back to Congress. Congress overrode his veto with a two-thirds majority. So it became law over the executive branch's, obviously, dislike of the law. So then Nixon decided, well, I'm just not going to spend the money to enforce the law that was passed. And that is called impoundment. It's an important word. You're probably going to hear this a lot. You may have already heard this a lot. So impoundment means the executive branch is not spending the money that Congress has told them to spend, that has authorized them to spend. And so kind of in a way, he was like, well, this is my way of like vetoing the bill, right? And so Congress, in response, passed a law called the Congressional Budget and Impoundment Control Act. You're probably heard this, or you will. Coming, it's in the news. So the Congressional Budget and Impoundment Control Act, and Title 10 of that act is called the Impoundment Control Act. And that requires the president to report to Congress anytime that there's a temporary delay in funding or a rescission of funding. A rescission of funding is a permanent cancellation of spending. So it requires the executive branch to go back to Congress to say, hey, we're not going to spend the money, or this is why we're not spending the money, etc. And so after this law, this was passed, there was a court case that went all the way to the Supreme Court back in 1975. It's Train versus City of New York. You're going to see it cited in one of the decisions that we're going to go over today. And it was a unanimous decision that said essentially that the executive branch had to spend the money that Congress allocated for this particular bill. Now, based on my reading of the opinion, I believe it's a pretty narrow holding. Now, what does that mean? That means that I think potentially it could be easily distinguished, which means we can say like, hey, we have this precedent out here, but we don't really need to follow it because it doesn't really apply in this case. It was a very, very specific, narrow holding based on the particular law that was at issue that, was causing the tension between the branches. And it was a very narrow holding that decided that, hey, in this for this particular law, based on the legislative history of this particular law, the executive branch needed to release all the funds that were allocated. So honestly, I think that this whole fight over federal funding freezing potentially may need to go to the Supreme Court. And just because we have this case out there from 1975 doesn't necessarily mean that the Supreme Court would need to follow that case. And in particular, and I'm going to point that out after we go through the cases, Congress really needs to act. If we're going to get any kind of relief, if the Trump administration is going to be able to cancel any of the funding that they want to, Congress is going to have to pass a law. So, and guess what? Funding is about to run out for the federal government. The CR expires on 15 March. And so it gives Congress a great opportunity to be able to change the allocation, the funding that they have in line with the Trump administration's plans. And so this is really a time for Congress needs to act and intervene, so it's not the judicial courts kind of getting in the way of the two branches. All right. So as I said, that OMB memo was rescinded, funding resumed, but the court cases lived on. So the district court issued a temporary injunction, a temporary restraining order, a TRO was issued in this case. And so I'm going to break it down for you. So let's look at the case itself. I'm going to share my screen. Let's find it. All right. So here we have the case. So it's in the United States District Court. Uh-oh, wrong one. All right. So we're in the District Court of Rhode Island. These are the plaintiffs. So the state of New York is kind of leading the charge, but we got California, Illinois, Rhode Island, New Jersey. On goes the list. Every single state is a blue state. Well, North Carolina, kind of purple, but the governor is still a Democrat. So Wisconsin, same, kind of purple, but they joined the lawsuit. So they're suing Donald Trump in his official capacity as president of the Office of Management and Budget, OMB, Department of Treasury. They're throwing everyone on this. Health and Human Services, FEMA, they're throwing all kinds of agents, Department of Transportation, Labor, Energy, EPA, Homeland Security, Department of Justice. They're just suing everyone. All right, so they're requesting a temporary restraining order, the states were. And in this decision, the district court granted that temporary restraining order. And let's get into the reasonings why. So the court lays out the legal standard for a temporary restraining order. And they say it's the same as a preliminary injunction. So the plaintiffs, they bear the burden. They have to prove their case. They have to prove these 4 factors. So 1, likelihood of success on the merits, potential for irreparable harm, balance of relevant equities, and we'll get into all of these, and then effect on the public interest if the court grants or denies the TRO. And so it's a pretty extraordinary relief. It is drastic remedy, absolutely, but this court seems real inclined to take it. And the court says fully aware of the judiciary's role as one of 3 independent branches. So the court recognizes that, hey, this is going to come to a head. This is kind of a fight between the branches of government, and talking about the separation of powers that restricts its reach into the executive branch. Now, a lot of talk on the right saying that this is a total usurpation of the judicial power, that it's absolutely trying to usurp the executive branch and kind of act as actually as the executive branch, that the court is trying to impose its judgment into the executive branch to decide what programs to fund and what's not. And well, there's some merit to that argument, but some really not. So let's get into it. All right, so likelihood of success. So the court finds that it thinks that the states actually have a really good argument. So they argue that these actions violate the Administrative Procedures Act, that Congress has not delegated any authority to the executive branch to indefinitely pause this funding. Essentially, they're arguing, hey, Congress gave us the money, Congress funded these programs, and your job in the executive branch is to do what Congress told you to do. Spend this money, right? So kind of like the case that we talked about earlier, Congress has said, they've passed a law that says, executive branch, you got to spend the money, or you got to tell us why you're not spending the money. And then, so the courts think it's failure, the executive branch failure to spend the funds is arbitrary and capricious. The states argue that it violates the separation of power because the executive branch is overriding Congress. So again, Congress allocated the funds, and the executive branch is supposed to spend the money. And so their argument is that because the executive branch is not spending the money, it's the executive branch who's actually violating separation of powers by not spending the money that Congress has told them to spend. Um, then alleging that it violates the spending clause, right? Not spending the money, violating the presentment clause, appropriation clause, take care clause. So the presentment clause, I don't really understand that argument because the presentment clause is essentially Congress passes a law, it has to be presented to the president. The president can veto it or sign it. Appropriations, yeah, I get that. So Congress appropriates the money, federal government should spend it. Take care clause, they should take care to faithfully execute the law. And so the court's considering that, hey, there's a whole lot of programs. So most states, I mean, I would say pretty much all states heavily rely on federal funding. Now, maybe with the exception of like Alaska and Texas. But most states, right, they can't print money. They're not like the federal government. They don't have a Federal Reserve to just print money out of thin air. And so states have to balance their budget. And oftentimes, states, how they balance their budget, how they pay their bills is through federal funding, that they heavily rely on federal funding. So these states are saying, hey, Congress allocated this money that's supposed to come to us to fund our programs, and the executive branch is pausing that. But obviously, the executive branch lawyers are arguing the other side and saying, well, we said we rescinded the memo, and the only funding we're going to stop are funding that has fraud. So if it's not a fraudulent program or if it doesn't align with the president's visions, right, these executive orders, we're going to allow the funding. All right, so they're saying that they're going to have this harm, right? So, and the courts think, hey, the states might win on these arguments that the executive branch is acting unilaterally. They don't have congressional authorization. And that's why I say I think to stop all this, to allow Trump to achieve his agenda, to get rid of the Inflation Reduction Act and the Green New Deal, to actually carry out what he feels like is a mandate by the voters, Congress needs to act. So if Congress stepped in and acted, that would help, that would alleviate these arguments, and that would allow the Trump administration to continue pausing and stopping funding for programs that do not have the support of the executive branch and probably generally most of Congress, or at least the American people. I don't know that Congress necessarily does the will of the American people. So, all right. So the executive branch, they're saying the executive branch doesn't have any legal authority to not fund, and Congress has said they've passed these laws and the executive branch should fund it. And so these states are saying, hey, we're suffering harm. We had less than 24-hour notice that we had a pause in these fundings, and we can't continue to function without these promised funds. And so again, the court thinks that the state has a legitimate argument here. As I've said, Congress appropriated these funds. They have not given the executive branch to limit or indefinitely pause the funds. And so the court in this case says, hey, states, we're probably going to win on count number one. And so it cites some case law to support that argument. The executive branch, they argued, the government lawyers, right, they're arguing that our duty to align federal funding and actions with the will of the American people as expressed through presidential priorities, right? So they're arguing that, hey, the president has a mandate and he's trying to fulfill that. But the court is saying, no, the executive branch has a duty to align federal spending with the will of the people as expressed through congressional appropriations, not presidential priorities. And that's why I say it's key for Congress to step in. If Congress really wants the executive branch to follow the will of the people, which I think I mean, Trump's approval rating today came out as over 50%. I think the majority of the American people want waste and fraud and abuse to be cut out of the government. And a way to do that is what Doge is doing and how they're cutting funding. So if the executive branch has the freedom to be able to do that, Congress needs to step in and give them that authority to do that. So I think to alleviate all of this, Congress needs to step in. So, but until Congress acts, we're left with these judicial opinions. All right. So, like I said, this is the case I was talking about earlier. So, back in the Nixon administration, remember, Nixon tried to do this, tried to not spend the money that Congress appropriated, and Congress responded with passing the Impound Control Act that says if the president wants to not spend money, they need to go back to Congress. And so they can't act unilaterally, meaning they can't act without Congress. And so it needs to go back to Congress. And so the court thinks, hey, you know what? The states are probably going to win on this argument. So they're definitely going to find that, yes, they have a substantial likelihood of success. And then quoting Brett Kavanaugh when he was on the DC Circuit. Now, I think this is kind of a nod and an understanding that the court recognizes that, hey, this could get to the Supreme Court. And so the district court here, the district court judge is kind of a nod to Brett Kavanaugh. Hey, you agree with me. And here's what you wrote back when you were on the DC Circuit. And see, he's citing that Train versus City of New York case. That's the case I was talking about, the unanimous decision during the Nixon administration that said, hey, the president can't just not spend the money that Congress authorizes. They have to go back to Congress to get approval to do so. And then they're going to go to the next, right? The 4 prongs. We got 4 prongs. So 1, likelihood of success. Check. They're saying, yep, they're probably going to win on that. So now irreparable harm. So this, like I said, states rely on that funding. And so the states are saying, hey, if we don't get that money, we can't do what we need to do. We're going to have disruption in services. The court points out to several different states and what they have said, this is what's going to cause problems. So Delaware saying highway construction, childcare in Michigan, veterans nursing care in Washington State, special ed in Minnesota, health programs in New Mexico. So there could hurt current disaster relief efforts in North Carolina, California's ongoing response to the fires. So the states are saying, hey, if we don't get the money, we're not going to be able to do the things that we need to do. And so the courts say, yes, you win on that too. So you're going to win on those 2 prongs. Now let's go to the 3rd prong. So balancing of inequities and public interest. Now the court decides to merge these last 2 prongs into one. And so the court says, hey, we think on balance that it weighs in favor of granting this TRO, which means Trump administration said we're going to pause funding, but the TRO would say you can't pause the funding. So it essentially unfreezes those frozen funds. And so this is the court's weighing it. So it says that the defendants are prevented from enforcing the directive contained in the OMB directive. So this is the government. So this is the Trump administration, the executive branch. If they are prevented from enforcing the funding freeze, then they would merely just disperse the funds that Congress has appropriated to the states. So they're saying, hey, there's not a whole lot of harm to the executive branch, because if I put this TRO in place, the executive branch is just doing what Congress told them to do. And then on the other hand, if they deny the TRO, then funding that the states and others would be in limbo. So they're saying, hey, this could be a hardship. We don't know how long this freeze is going to happen. These states can't do what they need to do. Minnesota is not going to have their special ed program. North Carolina can't provide emergency relief, which, I mean, they haven't really been doing it anyways. And so they're saying, hey, on balance, there's a lot more harm if we don't grant the TRO than if we do grant the TRO. So the court says we're going to grant the TRO. So I got some questions in the chat. I'm going to address those before I move on. So Holly says it's crazy that if fraud is found, the courts can mandate that the fraud is funded. Thanks goodness the CR is only until March and not to the end of the year. So we're going to get into the fraud piece a little later in a different decision. So the court at this level didn't address any kind of like fraudulent funding, just said these block grants, Congress had this block funding, and the government, the executive branch can't just unilaterally, without congressional approval, stop funding these programs. And so, yeah, I agree. I think let's hope Congress makes some deals. Let's hope Congress, actually gets off their breaks and does something. But I don't know. I don't have a whole lot of faith in Congress, and we have very slim majorities right now. So, I mean, if Congress would step in, do something great. But honestly, I think it's really going to come down to that new budget that gets passed in March. I mean, unless they do a CR again, they have to cut a lot of this funding out of that appropriation bill. So if they can cut a lot of that funding, then a lot of these cases go away. All right, so the courts are going to say, yep, on balance, states win. We're going to grant the TRO. Now, the government, like I said, they argued that this case is moot. Hey, we already rescinded the OMB directive. We're already going to press on, and we've unfrozen the funds. We're sending out the money. So this is moot. Just dismiss it. We're done here. We don't need to waste our time in court. But the court says, actually, they think that the messaging from the White House and agencies were contradicting this rescinding of the fund. So specifically, they point to the press secretary's tweet on X. And so, they say Twitter isn't real life, or X isn't real life. I guess it's X now, right? I can't dead name X. But so the president's press secretary sends out a tweet on X and says the president's executive orders on federal funding remain in full force and effect and will be rigorously implemented. So they're arguing that, hey, just because OMB rescinded doesn't mean that the Trump administration is going to actually pay these bills, that they are actually going to freeze the funds. And so and then they point to an email that was sent out by the EPA that said, hey, some grants and award money shouldn't be distributed while we're implementing the OMB memorandum. And now, I mean, communication is sometimes slow in the government. So it could be that this email sent out, and they didn't even realize that the OMB rescission had taken place. The memorandum had been rescinded. But nonetheless, the court points to these two things and says, hey, we think that this rescinding of the OMB memo was just a farce. It was just a way to get this case dismissed. But the administration is still going to freeze the funds. And so we think that the court thinks that this isn't mute. So they want to keep the status quo. And that's what its temporary restraining order does. The temporary restraining order should keep that status quo until there's further hearing. And so to keep the status quo, we got to unfreeze the funds. And so the district court is unfreezing the funds that the Trump administration put on pause, put on freeze. And then the court issues a warning. Hey, executive branch, I know what you're going to try to do. You're going to try to just change some names and still, freeze these funds. So it says, hey, during the restraining order, make sure that you disperse the funds. Make sure that you don't do anything to pause, freeze, impede, block, cancel, or terminate any of these funds They need to be issued. And so that went out. So this order was granted on February 3rd. So this was, and it's going to be in effect until a further order of the court. So actually, I guess it was on the 31st. Sorry, my apologies. So it was issued on the 31st, but they needed to give written, that's what it is. They give written notice to all the agencies by February 3rd, 9 a.m. All right, so that was January 31st, a little over, 12 days ago. So what happened in the meantime? Why was there a big fuss today on Twitter? All right, so I'm going to take this one off the screen and go to the next one. So what happened in the meantime? What happened in the meantime is that the states went back to the district court and said, hey, the Trump administration, they're not doing what you told them to do. They're not following the TRO. They are still freezing the funds. They didn't unfreeze the funds. And so they went back to court to say, hey, court, you got to tell the Trump administration to knock it off, unfreeze these funds. We want enforcement of the temporary restraining order. And the court granted it. So this was issued. When was it issued? Let's find the end. February 10th. So this was February 10th. So yesterday. So the states went back to the district court and said, hey, the Trump administration's freezing the funds. We want you, court, to tell them to comply with your temporary restraining order, unfreeze the funds. So the court explains, hey, this is what they did. The executive branch had this broad, categorical, all-encompassing directive, that OMB directive, remember, that was rescinded 2 days later to freeze federal funding. The TRO in this case prohibited categorical pauses, freezes in obligations or disbursements based on the OMB directive or executive orders. They had notice of it. It was clear, unambiguous. They should have followed it. So the judge is pretty upset. Hey, you didn't follow my order. But the Trump administration is saying, hey, you're usurping our power. Hey, executive branch. I mean, what did Andrew Jackson famously said? Hey, court, come enforce your order, right? So the states have said, hey, they have evidence that the defendants have continued to the government. So the defendants are the executive branch, right? Have continued to improperly freeze federal funds and refuse to resume disbursement of appropriated funds. So the states, remember, they're relying on those federal funds and they're saying, hey, we haven't got our money. We need our money. And so then the executive branch comes back and says, no, we're just trying to root out fraud. There's huge fraud, and we know that is true. There's lots of fraud, waste, and abuse. And so the defendants are saying, we're just trying to root out fraud. There's a lot of fraud in these programs. That's what we're freezing. We're freezing and canceling fraudulent programs. And so they're saying these freezes were not a broad categorical order. This was fraud. We're looking at fraud. But the court, remember, this is when they talk about the court, it's talking about itself. The district court judge was talking about himself. The court says, hey, these broad categorical orders are likely unconstitutional. And so you can't do that, executive branch. And it says these pauses violate the TRO. All right. So, but the judge says, hey, defendant, government, executive branch, if you find fraud, you can request targeted relief from the TRO, from this court, this judge, this district court judge in Rhode Island, if you show us specific incident that they're acting in compliance. And so I saw some meltdowns on Twitter that this is what they were talking about. Hey, the federal government can't freeze funds without uh, approval from the district court judge. That's what they're talking about. They're talking about this highlighted portion right here in the opinion, saying, "Hey, executive branch, if there's certain things that you want frozen, come back and ask me, but don't do broad categorical freezes." So, district court in Rhode Island says, "Hey, executive branch, you violated my TRO, so I'm going to further order you immediately restore frozen funding, unfreeze those funds, send the states their money. They want their money. Immediately end any federal pause, take any necessary steps to ensure that they follow the TRO, restore those withheld funds, and then not to follow any of these executive orders." The courts are saying these are likely unconstitutional. They likely violate the Impound Act, right? The Impound Control Act, that law from the Nixon administration. And so they're saying, hey, don't follow these, follow the TRO instead. All right. And so they got to resume funding, particularly funding like the National Institute of Health. And so that was issued by, right, the Chief Judge, District Court of Rhode Island, Judge McConnell Jr., yesterday, February 10th. So what happened in response? So the government, the executive branch lawyers, filed an emergency motion to the First District Court, or the First Circuit Court. So the District Court of Rhode Island falls under the First Circuit. So they filed an emergency motion in the First Circuit. And that got ruled on today, which is, I mean, in terms of judicial action, they're moving at incredible speed. Court cases usually take long time. There's one court case that I can think of off the top of my head that from the time the original complaint was filed to all the appeals, all the way up to state Supreme Court and back down and back up and back down, it was 10 years before it was all resolved. So court cases usually take a really long time. So the fact that that First Circuit, we had an opinion yesterday, and the First Circuit had issued an opinion today. Yeah, it's pretty fast. So here's the order from the First Circuit. So the First Circuit says, basically, government, you're here too early. So I think there's been a lot of misinformation about what the First Circuit issued today. It was pretty unclear from the 120 characters tweets that I saw about it. So let's read it because it's pretty short. It's only 2 pages, and I think it'll put to bed a lot of the misinformation. So, all right, the court, right? That's today, February 11th. Oh, it's my brother's birthday. I got to make sure I text him. All right. So on January 31st, right, the district court granted that TRO that we just went through, right? So we had, and then they extended the TRO on February 6th. So this was the January 31st was that opinion that we went through. And then February 6th, the district court entered a text order, which means it was just like on the record. So when I looked it up on Pacer, which is the court record system of all federal courts, it didn't have a written opinion. It just had a transcript essentially from the hearing. So they extended the TRO. And then February 10th, that was yesterday, that's the opinion we just talked about, granted the motion for enforcement. Remember, the states are saying, hey, we didn't get our money, unfreeze the funds. And so the defendants, that's the Trump administration, the executive branch, have appealed these orders. All right. And then they separately filed 2 motions. So they want to stay pending appeal, which means, hey, tell the district court they can't do anything. That's what they wanted. They wanted that resolved by February 14th, which again, like lightning quick in terms of judicial opinions. That's, I believe, what, Friday? And then an administrative stay pending resolution of their motion. So they're saying, hey, right now, all we're going to talk about is this request for a stay, which means they're asking this higher court, the First Circuit, to tell the district court judge, that judge from Rhode Island, hey, stop doing what you're doing until the First Circuit, resolve these appeals. And so the court said, we're only going to address this request for a stay. And so we're saying that they're saying the defendants have requested a stay, but they look down at the district court and they say the district court hasn't even ruled on their motion yet. So this First Circuit is saying, hey, there's still a lot outstanding down at the district court level. And so generally, you have to resolve, that's what these cases are saying. Generally, you have to resolve everything down at the district court level before you can move up to that higher court. And so they're saying to the government, you're kind of jumping the gun. Hey, executive branch, you're moving a little too quick. You got to work it out at the district court level before you come up to the circuit court level. And so they're saying what is really at issue between the two parties is that February 10th order. Now that's the temporary restraining order, right? Saying that we just went through, that essentially said, right, we just reviewed it, said, hey, you got to unfreeze the funds, no more block freezing. And yeah, if you find specific fraud, come ask me and I can grant you, relief from the TRO on these like specific fraud issues. So that's really what's at issue, right? So the executive branch is saying, hey, the judicial branch is trying to do our job, is get in the middle of what we should be doing. And so they're asking for relief from this higher court to tell that lower court, stop doing what you're doing, knock it off, district court judge. And the higher court, the First Circuit, is saying, actually, no, I think yes, you got to stay back down in the district court. You're here too early. So they say the defendants, the executive branch, isn't citing any authority in their stay request or identify any specific funding or funding actions that they request that they'll have, like any specific harm that they will have if they don't get a stay. And now I read the executive branch, the defendant's motion in support of the stay. I'm not going to review it here just for time's sake, but they are kind of, the court is correct in that they did not cite anything specific. So there was nothing in the defendant's request for a stay that said, hey, here's the specific harm, here are the specific funding actions that we have identified that are fraudulent, that we would, the taxpayers would suffer harm if we would have to disperse these fraudulent funds. And so, could just be, this is quick turn. And I'm going to tell you, filing motions with less than 24-hour notice, it's a heavy lift. So it could just be an oversight by the government attorneys. I think there's lots of fraud that they could have identified, and they just failed to cite it. So this case was actually dismissed without prejudice, which means they could refile. So they could fix this. They could go back and say, hey, here's some specific things. But the First Circuit Court is saying, you need to go back to the district court. So if you have these specific things, go back to the district court, ask for the district court to allow you to get, essentially relief from the TRO to block the funding of the district court. So we got one last paragraph. Let's go through it. So in these circumstances, we assume we have jurisdiction. They're just saying, yeah, for sake of argument, we think we have jurisdiction. We have the ability to hear this case, and we're denying this motion for an administrative stay without prejudice. Like I said, that means the government can come back. So the executive branch could come back to the First Circuit if things change, or like I said, if they get this better argument, right? If they find the specific areas that they're saying, hey, these are fraudulent funds that are going to go out, and the court's going to make us send funds to, out to, that's going to cause harm because we're going to send funds when they shouldn't, or there's fraud or waste or abuse. So if they can cite specific things, I think they could potentially make a good argument to come back to the First Circuit. But the court at the First Circuit is saying, we are confident the district court will act with dispatch, which means they're going to be quick. So, hey, if government executive branch, if you have any issues with the TRO or if you need clarification, go back to the district court and, hey, hint, hint, district court judge, you better be quick. To provide any clarification needed with respect to, among other things, the defendant's contention that the February 10th order, so this is what the government, the executive branch, the defendants are arguing, quote, bars both the president and much of the federal government from exercising their own lawful authorities to withhold funding without prior approval of the district court. And so the court says, First Circuit here, hey, you didn't give us any specific instances where the district court, were stopping the president from exercising their lawful authorities. So maybe come back, or better yet, go to the district court first. And then if you don't get relief, then come back here. It says, so we note in the regard to the plaintiff's statement in their opposition to the defendant's motion for the administrative stay pending appeal, so that the plaintiffs in this case are the states, those individual states that are suing the executive branch, consistent with the TRO, the February 10th order, that's the one we just did, quote, does not stop the defendants from limiting access to funds without any preclearance from the district court on the basis of applicable authorizing statutes, regulations, and terms. So the states are conceding, hey, if the executive branch has the authority to stop funding based on existing statutes, regulations, and terms, we don't think they need to come back to the district court. We think they can just follow the law. And so the First Circuit is saying, hey, yeah, they seem to agree with that too. So they said, hey, parties, you got some time. You can file anything further with this court, but you got to do it by Thursday, February 13th. And then I think we'll likely hear again from the First Circuit by Friday, the February 14th. So what does that mean? That means I'll be live streaming again on Friday about this topic. So we'll see what happens between now and Friday. We got a couple of days, and we'll see what the First Circuit says. But based on this decision, the funding has been unfrozen and they're back at the district court. So we'll probably be back here Friday, if not sooner, to discuss this case. And I'll be discussing the next several evenings. I'm going to attempt to live stream each evening. So if you like the content here, please like, share, subscribe. I'm a new channel. Please share this out there. And if there's any topics you want me to cover, any specific EOs or cases that you want me to discuss, leave it in the comments. So leave some comments. You can also find my Rumble channel, and I'm on X. So you can follow me there. And I will, if you don't join me tomorrow, for sure, come back Friday and we'll discuss, we'll see what happens in this case in particular, see what happens with the funding, and see what happens in this case. Over the next couple of days, I'm going to be breaking down other cases that are currently pending, challenging the Trump administration's executive orders. And so tune in for military lawyers' perspective on all these cases pending and trying to block Trump's executive orders. So I'll catch you in the next video. Thanks for tuning in. Have a great night.